If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why?
If a president sells nuclear secrets to a foreign adversary, is that immune? How about if a president orders the military to stage a coup?
You seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
Earlier today, the United States Supreme Court finally heard oral arguments pertaining to one of the most important constitutional questions in American history: whether Donald Trump or any ex-president is entitled to absolute lifetime legal immunity from criminal prosecution for anything they do while in office. In other words, do we have a president or a God King? And the arguments offered by Donald Trump's attorneys were so despicable, they will make your skin crawl. But before we unpack all that, if you end up liking this video and you want to support the channel, please be sure to hit the like, subscribe, and alert bell before you go. I'd greatly appreciate it. All right, friends, this is one of the most important videos that I've ever made, and it's about one of the most important court cases in American history. Certainly one of the most important to make its way in front of the United States Supreme Court. We have a lot of clips to look at, okay? And we could probably do multiple videos about this, and we may very well. And the clips in question pertain to the first half of the oral arguments in the Supreme Court case concerning Trump's attorneys in the United States Supreme Court, which, as a reminder, has a 6-3 conservative supermajority, so they are Republican aligned, and 3 of the 6 were appointed by the defendant himself, Donald Trump. Before we play the clips, I'm going to give you just a brief recap very quickly of what Trump's argument is, or his attorneys. President of the United States can't be prosecuted for official acts. Immunity is absolute. That's a direct quote. Number 2, in determining whether something is an official act, you can't examine the motive behind it. In other words, whether it was for personal gain. Number 3, POTUS, the President of the United States, can be prosecuted for official acts if they're convicted and removed first via impeachment. Number 4, to be prosecuted, the criminal statute has to specifically say it applies to the president. A criminal statute has to directly specify, according to Trump's attorneys, that it applies to the president for the president to be held under it, even after he leaves office. Think about that. In any prosecution, you can't introduce evidence that would constitute an official act. So if prosecuting bribery, you can't show that they did anything official in return for the money, which is an element of the offense. So as an example that they bring up, if any president is basically bribed, given $1 million to appoint somebody as an ambassador, and the president has the power to appoint people as ambassadors, but that's an official act. And so if you want to prove a bribe, you can't introduce the official act to the jury. So in exchange for becoming an ambassador, you're given $1 million. You can't point out that the president appointed the ambassador. You can't actually introduce the official act, which means you can't prove bribery, which means you can't prosecute them. And even though you can't prosecute a former president for unlawful official acts, anyone who does his bidding can be. So the president is immune, but his underlings can't. That's the context for all this. So with that in mind, let's play some of the clips. In this one here, and again, some of these clips are long, folks, but it's so important. I urge you to pay attention to this for your sake, for ours, and for the future of democracy. So in this case here, Justice Sotomayor asks Donald Trump's attorneys about, again, the assassination of a political rival, which you've heard before, but this is important.
Can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say, if you stay by it, if the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
They could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we
Harlan,
go back
Johnson,
to
and so
Justice
forth.
Thomas.
So the bottom line is that once again, Trump's attorneys are saying that a sitting president cannot be criminally prosecuted even if he assassinates a political rival. You would have to impeach and convict him first. And we've gone through all the contingencies that would make that incredibly challenging, if not impossible. What if we don't find out about the criminal offense until after that person leaves office? What if the president in question assassinates or threatens a sufficient number of lawmakers to prevent impeachment or conviction? Sauer says that's the only remedy, even if a president assassinates a political rival, and even if it appears to be for personal political gain and not in the best interest of the country. Folks, this is super gross stuff. But wait, there's more. So they ask about, creating fraudulent slates of electors, as Donald Trump is alleged to have done by the special counsel. What about that? Can he be prosecuted for that? Is that a private act, or is that an official act as president?
Apply it to the allegations here. What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible that would be within his right to do?
Absolutely, Your Honor. We have the historical precedent we cited in the lower courts of President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment or even
knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis.
So again, Sauer's attorney is arguing that a sitting president running for re-election can, scheme to create an alternate slate of electors, fake slates of electors, people who were not appointed to be electors by their state, people who were not certified as electors, a fake slate that would produce a beneficial outcome for him in a capacity as a political candidate in a presidential re-election bid. And Sauer's attorneys are arguing, but because he's the sitting president at the time, it counts as an official act, because aren't presidents supposed to ensure election integrity? Even though it has no relationship with election integrity. It's about producing a very specific outcome for the sitting president directly. Super gross stuff. You might think, well, that's absurd. But Sauer's attorneys say that a president can't be criminally prosecuted even if they sell nuclear codes to a foreign adversary.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the Blazing Game analysis or even the Fitzgerald analysis that we've been talking about.
So what he's saying is, even though it sounds like a private act, it could be plausibly an official act depending on how the president worded the sale of the nuclear codes to a foreign adversary. Folks, this is how broad Trump's attorneys are making the proposition. And you might think, well, that's insane. Surely it doesn't get worse than assassinating political rivals and selling nuclear codes to foreign adversaries. What about a coup?
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act. If one adopted Justice Alito's test, that would fall outside. Now, if one adopts, for example, the Fitzgerald test that we advanced, that may well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize to the court that—
Well, he's gone. Let's say this president who ordered the military to stage a coup. He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief. He talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand, because the framers viewed that kind of
If
very
it's an
low
official
risk.
act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't.
Trump's attorneys are arguing that the president unlawfully ordering the military to stage a coup, and a coup by definition is unlawful in the United States. The president, no matter how popular, is not legally entitled to overthrow the federal government, which includes the other two branches. Trump's attorneys are saying, well, that might constitute an official act that would immunize that person from criminal prosecution, barring impeachment and conviction. Of course, impeachment and conviction being impossible in the event of a successful coup by a citizen. You see the circular logic? He would have to be impeached and convicted first by a Senate that he has just overthrown, or by a House that he's overthrown and convicted by a Senate that he's overthrown. And an attempted coup where it's not successful and then we don't find out about it until after he's left office, well, you can't prosecute them because he'd have to be, again, impeached and convicted first. All of this, just specific outcome oriented. And then he tries to cite the founders. The founders absolutely would not. There is no sufficient evidence that if you presented these hypotheticals to the founders, they would be like, yeah, of course the president is criminally immunized from attempting a coup. What basis is there for that? Absolutely despicable stuff. Ketanji Brown Jackson, Justice Jackson, the justice appointed by President Biden, she finally gets fed up at the end, and she puts it beautifully, because Donald Trump's attorneys, are saying, listen, if you can criminally prosecute a president, if a president is beholden to the law, maybe they can't act vigorously and bravely as we expect our chief executives to do. It could have a chilling effect. This is what Ketanji Brown Jackson says brilliantly and beautifully.
Sue him. But when we're talking about criminal liability, I don't understand how the president stands in any different position with respect to the need to follow the law as he is doing his job than anyone else.
He is required to follow the law. And what Fitzgerald
But he's not
said is
if there's no criminal prosecution. If there's no threat of criminal prosecution, what prevents the president from just doing whatever he wants?
all the structural checks that are identified in Fitzgerald and a whole series of this court's cases that go back to Martin against Mott, for example, impeachment, oversight by Congress, public oversight. There's a long series of them. Fitzgerald directly addresses this in the civil context, and we think that language naturally ports.
I'm not sure that's much of a backstop. And what I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
I don't think there's any allegation of that in this case. And what George Washington said is, what Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional. And what George Washington said is, we're worried about factional strife, which will.
No, I'm also, let me put this worry on the table. If the potential for criminal liability is taken off the table, wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office? It's right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But
again, brilliantly said, folks. And again, the whole hearing, and I only heard the first half. I have not gotten to the part yet, unfortunately, where the Solicitor General on behalf of Special Counsel Jack Smith had his turn to talk. I can't wait to hear that. But Ketanji Brown Jackson, Justice Jackson is absolutely correct. So what about emboldening the most powerful person on earth to engage in criminal enterprise? You say that Sauer says, well, of course the president is obligated to obey the laws. Well, so is every citizen, and part of that obligation comes with the potential to face the consequences if you violate the laws. And Justice Jackson's correct. If you remove that potential consequence, then what you're saying is that a president should just pay lip service to the law, but there's really no meaningful way to hold them accountable. They should follow the law. Oh, does that mean we can hold them accountable if they break it? Well, no. It's just, it's kind of like a gentleman's agreement. It's insane. And she's also correct to point out, because Sauer says this repeatedly, well, this has been the case for 234 years. Justice Jackson's correct. Based on what we know, it is the understanding of presidents since Washington that they could be criminally prosecuted if they broke the law while in office. So she says, she offers a counter proposition. Perhaps that's the reason why this system has worked for 234 years, that those who occupied the Oval Office understood it to be the case, that if they break the law, they could be treated like everybody else. You, John Sauer, you, Donald Trump, would be removing that disincentive and basically giving them carte blanche to do whatever they want. He has no satisfactory answer to that. Incredibly despicable stuff, people. What the Republican Party, what Donald Trump and what his attorneys want is a monarch, a sovereign, not a president. We have a president, a chief executive, a powerful chief executive, but one obligated to obey the law and one checked with checks and balances. That's the way it should be. And what Trump and his attorneys want, and what Republicans in the cult want, is to remove one of those critical checks, which is the threat of criminal prosecution if you break the law while in office. Absolutely gross stuff. I'll also remind you that Donald Trump's current position, which is everybody, presidents, not just me, you need absolute legal immunity. I will remind you, I love playing this clip because it's the ultimate Trump card, pun intended, which proves that Donald Trump is an unprincipled hypocrite who should not be respected on this position or anything else. When Donald Trump was the sitting president, he tried to get a former president, Barack Obama, his arch nemesis, prosecuted by his own DOJ.
But I'll tell you, Bill Barr and Durham have a chance to be, Bill Barr has a chance to be the greatest of all time. But if he wants to be politically correct, he'll be just another guy. Because he knows all the answers. He knows what they have. And it goes right to Obama, and it goes right to Biden. They had the meetings. That was one meeting they caught him. They had many meetings.
And we played the other clip as well, where he said that Bill Barr should prosecute Joe Biden and Barack Obama, a former president of the United States. So Donald Trump, as the sitting president in 2020, clearly didn't believe that ex-presidents were entitled to absolute legal immunity. Otherwise, he wouldn't have tried to get Bill Barr to prosecute an ex-president. It just so happens to be whatever is convenient to Donald Trump in the short term. When it's convenient to him, presidents don't have immunity. When it is convenient to him, they do have immunity. When it's convenient to him, you can't prosecute, you can't impeach and convict a former president. When it is convenient to him, you have to impeach and convict a former president before you can prosecute. Chris Hayes pointed this out. Something that drives me a little insane, I'll admit, is that Trump's own lawyers at his impeachment told the senators to vote not to convict him because he could be prosecuted if it came to that. They did say that. Listen, if you want to go after former President Trump, you go after him with the Justice Department. You can't impeach and convict because he's an ex-president, not a sitting president. As Chris Hayes points out, now they're arguing that the only way he could be prosecuted is if they convicted. It is totally self-serving. It is completely unprincipled. It is the Republican Party to its core. Folks, this is without question one of the most important constitutional cases before the Supreme Court. And I am worried about how it will come out. I like to imagine that even this right-wing court, especially with a liberal or progressive, a Democrat in office right now, I hoped that they would not entitle ex-presidents to absolute immunity. But who knows? I don't know. And they may kick it back to a lower court to try to gum up the system and delay on Trump's behalf. Super despicable stuff from this fascist cult, which is MAGA, and we should categorically reject it. No president and no former president, Biden, Trump, Obama, Clinton, whoever, Bush, should be entitled to a blank check of absolute legal immunity for anything they do while in office. That's monarch shit, and we should reject it here. Let me know what you think in the comments.